I have this slide up just so everybody can look at it and refresh their recollection as to what the definition of public works means. There were 3 California Superior Court cases in 2021, which specifically went through the definition of public works. So I think perhaps going forward, we all may have some guidance as to what is and what isn't a public work. So, first case, the Busker case. In this particular case, electricians were installing electronic components on Metrolink train cars and the locomotives. And they said, hey, this is a Metrolink train. It's a public entity. We're entitled to prevailing wage. So the California Supreme Court looked at this, and they looked at that specific definition of a public work that was in the slide before. And they said, wait a second, looking at that definition, it doesn't include trains. It doesn't include rolling stock. And I wasn't aware of this, but rolling stock actually has a definition, and it means a train or a locomotive, things obviously that roll. But the court said that this is not covered because it's not specifically set forth in the statute. Okay, so that is interesting case number 1. Robin, go to the next slide, please. Interesting case number 2 is the Mendoza case. And for those of you who were at a prevailing wage presentation I gave, I think it was 2 years ago, this particular case was winding its way through the Ninth Circuit and through the courts, and the Ninth Circuit certified this case to the California Supreme Court because they didn't know what to do with it either. So in this case, union equipment operators wanted prevailing wage for their off-site mobilization and transport of heavy machinery to a public works construction site. And Mendoza, the plaintiffs in the case, said that this was ancillary work and it needs to be paid under the definition of 1772, which states contract for public work is deemed to be, if the employee is deemed to be employed upon public work. So Mendoza was looking for an expansion of this. And the courts rejected this argument. And the court said, you know what? We're looking at the specific language in the labor code section, in the labor code statutes that defines prevailing wage. And it does not include ancillary work. This was a huge decision because the DIR and case law had a whole series of cases expanding the definition of prevailing wage and public works. And the court basically said you can't do that. And the court kind of set aside all those prior decisions. Now, clearly this case stands for that mobilization and transportation of equipment to a public works job site is not prevailing wage. The big deal in this case is, what is prevailing wage? What about, and this is the situation that comes up, what about when a trucker brings material to the job site that's immediately incorporated into the work of construction? For years and years, the DIR was saying that that was always prevailing wage. This particular court basically just said outright, they said, you know, that definition immediately incorporated into the work of construction it's not clear. Nobody knows what it means. And so the court said, we're not going that way anymore. We're going specifically the language of the statute. Here it is March 2022, what I've heard about this issue from the DIR is that they are now saying that this is no longer prevailing wage, and that they're not going to claim that any work and the material that we talk about is always asphalt is not going to be prevailing wage. So that's what their position is. That's what their unofficial position is. I think we need a little bit more time for this to actually be enforced or not enforced, or for DIR to solidify their opinion regarding this. So the third public works case that came out is Ka'ana'ana versus Barrett Business Services. And this case was bizarre. In this case, the garbage sorters at the LA County dump said, hey, we need to get paid prevailing wage. And the court agreed with them. And the court basically said that there's another labor code provision under the prevailing wage statutes that specifically says that work done for districts similar to irrigation and improvement districts, all of that work is prevailing wage. So these garbage sorters at the dump are now entitled to prevailing wage. So looking at these three cases, Robin, can you go to the next slide? Looking at these three cases, this is the takeaway from these cases, is that the court, and this is the California Supreme Court, so they're the ones who were involved in all three of these cases. Their signal is that the statutory scheme for public works doesn't make sense. And what we're going to do in the future is that we are going to enforce it and interpret it specifically as it is written. We're not going to expand it. We're not going to minimize it. It is the way it is. And it has very, very absurd effects. Did the legislature actually intend that garbage sorters at the dump get paid prevailing wage? Probably not. But until the legislature fixes it, this is what we're stuck with. And I know prevailing wage is a landmine for contractors, and especially for trucking companies. And if only there was some specific guidance as to what is and what is not prevailing wage, it would, obviously it would go a long way. And hopefully the DIR is either going to provide that to us, or the legislature is going to provide that to us at the invitation, obviously, of the California Supreme Court.